This is Judge Chris Martin.
Hello, sir.
Hang on just one moment. Yes, I'm trying to read. Is this, I'm trying to reach Michael Lee Doan. Is Michael Doan
Yes,
on?
hold on 1 minute for him.
Okay, thank you.
Yes.
Hello? Hello?
Mr. Doan.
Oh, yes, sir.
Okay, I want you to just stay where you're at for just a moment. Your attorney's getting set in the courtroom, and we'll begin in just a moment.
Okay.
Mr. Adams, can you unmute that device? Just look on that device. I'm sending a button. All right, this is cause number CR 15-512-513, State versus Michael Lee Doan Jr. Record will reflect that Mr. Doan is currently incarcerated in the Texas Department of Criminal Justice and is appearing in this hearing via Zoom, as well as the court and Mr. Adams appearing at the Van Zandt County Jail. Mr. Adams, Mr. Doan is set for status today, and I think it may have been status to get you and he in contact with one another based on his status in TDC. If I'm incorrect on that, please correct me.
No, that's correct, Your Honor. Mr. Doan and I have exchanged correspondence a couple of times. This is a motion to adjudicate, I believe, and this case is from 2015. Having not been able to effectively communicate with Mr. Doan up to this point, I haven't had discussions with the state about a plea offer in exchange for Mr. Doan's pleas of truth, but I also don't have a copy of the motion to adjudicate yet. And so I hesitate to enter into those conversations until I've seen a copy of that motion. Mr. Doan has been in the custody of TDC for a considerable amount of time. I think this motion to adjudicate has been, from what I understand, has been on file for a while. I am optimistic that we can resolve this without too much trouble. I would note that from the information I've been provided and the information I have seen from the TDC website on current inmates, that Mr. Doan's projected parole out date is January 24, so about three and a half weeks from now.
Okay. State, any response on, is the motion to adjudicate not included in your online discovery?
Judge, it does appear to be in the portal.
You said it does? You said it does or doesn't?
It does appear to be in the portal. I will also email Mr. Adams a copy right now just to be doubly sure that he has it.
And we believe that Mr. Doan may parole out in the next month?
Yes, that's correct. But I apologize for overlooking the motion on the portal. I've got a lot listed there.
Okay, and Mr. Doan, you've heard your attorney, Mr. Adams, is that correct?
Yes, Your Honor.
Do you have any reason to believe that you may not parole within a month?
No, Your Honor. I actually been told my official release date is the 22nd.
Okay.
Your Honor, since we've got Mr. Doan on the telephone, do you mind if I ask him a couple of questions?
Do you want it to be under oath?
No, it wouldn't be under oath.
All right, go ahead.
In the context of Mr. Doan, hey, this is Mr. Adams. When you parole out, where are you going to be located?
They've actually approved my address at my grandmother's house in Paris, Texas.
All right. And were you given a copy of the order that appointed me to represent you?
The copy of the order?
Yes.
I believe so. Yes, sir.
Yeah, I guess my point is, do you have a document with my telephone number on it?
Oh, yes, sir.
Okay. Would you do me the favor of, once you get settled, would you give me a call so that I know how to get a hold of you?
Get settled as in once I get out?
Yes, yes, just get in touch with me, let me know the best phone number to reach you, that sort of thing, so that we can keep the lines of communication open.
Oh, yes, sir. I was actually kind of concerned. Is this going to affect me getting out on the 22nd, or am I going to be able to get out and then deal with it?
Well, I don't want to get into advising you on the record in front of the state and the judge. My short answer is going to be I don't think so.
You don't think it should affect me getting released?
My short answer is I do not think so.
Okay.
Is Mr. Doan currently on bond on both of these cases? Because if he's not on bond, I would anticipate that TDC would notify Van Zandt County to pick him up. He would remain in custody until he's before this court.
Right. I don't think that these motions in Van Zandt County, these pending motions in Van Zandt County would necessarily postpone his release from TDC, but upon his release, if there's a hold in place, then I think you're right. Van Zandt County would go up and get him from there. And there's not a bond amount noted on the order appointing, so I don't think that there is a bond for what's going on in Van Zandt County.
Judge, it looks like there are MTR warrants out, MTR hold for Mr. Doan in Justice Solutions.
So what that means, Mr. Doan, basically, as I can tell, that the motion to revokes in these cases are going to hold you not from being released from TDC, but rather being released from TDC to your parole address with your family member. So most likely what will happen is Van Zandt County will be notified to pick you up from TDC and then bring you to the Van Zandt County Jail, at which time we can have another hearing with Mr. Adams in the state and determine the resolution of your case. So I think both answers are correct. I don't think that's going to affect your ability to parole out. It's just going to affect your ability to parole to a certain place. Does that make sense?
Yes, Your Honor.
Okay. So what I'm going to do is that's on January 22nd. Anticipate if you parole out that date, then Van Zandt County will be given some time in which to pick you up or not. I'm going to set this. Let me look at my calendar real quick. Mr. Adams, are you available on February 9th?
Yes, Your Honor.
Let's just go ahead and set Mr. Doan on February 9th. And we'll put that on status as well for custody. So, Mr. Doan, what I'm going to do is by setting you on February 9th, if you are released to Van Zandt County custody, then that will be the next available date. I could probably get him in on the 28th, potentially, but I don't know how long it's going to take for Van Zandt County to exercise picking him up. Okay, so I'm just going to go ahead and set it on the 9th. If he gets here sooner and I get notified that he wants to resolve his case, and Mr. Adams, you can contact the court. I can try to get you in there sooner than later.
I'll keep on top of it.
Is there no way we can resolve it today or by telephone or fax?
Mr. Doan, there are certain things that I need to do before I can help you with that.
Oh, okay. Yes, sir.
So unfortunately, there's paperwork that has to be considered. There's discovery. There's things legally that Mr. Adams has to do before he can advise you one way or the other. And even before the court could accept any type of disposition, you would need to be present in court. At least the court would at least need to have some paperwork before it that shows that you've reviewed it, signed it, and that you understand it. So we're not that far along in the game. So as soon as you get back here, I'll get you in here as quickly as possible, and we'll try to get you moved on. Okay.
All right. Thank you, Your Honor.
Mr. Doan, if TDC releases you to your family and Van Zandt County for some reason doesn't pick you up, the hold isn't honored, whatever the case may be, if you're released to your family, then you are ordered to, contact Mr. Adams as soon as possible, and then be back in this court in person on February 9th at 9 a.m.
Okay, yes, sir, Your Honor.
Okay, so what date did I tell you?
February 9th.
Okay, if you haven't written that down, get that written down, okay?
Yes, sir, Your Honor.
Okay, all right. Mr. Adams, anything further with Mr. Doan?
No, sir.
All right, thank you. All right, thank you, Mr. Doan. We'll see you soon.
All right, thank you.
Mr. Doan, tell the TDC staff I appreciate their assistance today.
I will.
All right, thank you.
All right, bye-bye.
Mr. Gimbel, who are you ready on?
This is Mr. James Wilburn.
All right, this is CR 2275, State versus James Grady Wilburn. We're set for docket call today.
That's correct.
Go ahead, Mr. Gimbel.
And just want to notify the court that Mr. Wilburn has rejected the state's plea offer. And he has also indicated that he is requesting other counsel.
What is the state's offer?
The offer was 4 years TDC.
All right, Mr. Wilburn, why are you requesting new counsel?
Your Honor, he has just come today the first time with the discovery pack, and he has the disc, but he did not bring the laptop. I've been incarcerated for almost 180 days, and I still have yet to go over anything on the case with him. And I just feel like he's not doing anything to work with me on my case, and I would just like a new attorney.
Mr. Gimbel, would you like to respond?
Your Honor, I visited with Mr. Wilburn. I was appointed in August. I requested discovery, and when I received discovery in October, I visited with Mr. Wilburn, and I visited a couple of times, and I'm sorry the case just hadn't moved as quick or as well as he hoped for.
Have you gone over the discovery with him, including the video discovery?
Other than the video, yes, I have, Your Honor. I set out a laptop to bring it with me today to view the video and left that in my office. So I have not reviewed the video with Mr. Wilburn, but we have gone over. He's had an opportunity to read the discovery.
Have you reviewed the video, Mr. Gimbel?
Yes, I have looked at it.
Is there anything that is different in the video than in the written discovery?
It's pretty much just a body cam video of the officer that was present.
I understand. Is there anything different between the video and the written report?
No, Your Honor.
All right, Mr. Wilburn, is there any other reason that you don't want Mr. Gimbel to be your attorney other than what you stated?
No, sir. Just that he just now brought the discovery for me to review today before court, and I know that last time we come up in front of you, Your Honor, that you had asked for me to either accept your offer or to know whether I wanted to go to jury trial or bench trial, and I haven't even had enough time to think about my case or anything that's been in the discovery packet. I mean, he literally just come and showed me the discovery pack this morning at 11:30, about 11 o'clock, 10:30 or 11. And this was my first time to go over the discovery pack.
Mr. Gimbel, is today the first time for your client to review the discovery?
Today is the first time for him to have hands-on on the discovery. When I met with Mr. Wilburn in October, and again in November, we were in the visitation room, and I was unable to slide the discovery pack back and forth for him to read. I basically summarized it and read it to him.
Okay. Gentlemen, I think what would be best is, rather than appointing new counsel, is I'd like to give you some more time, Mr. Wilburn. I'm going to give Mr. Gimbel some more time to bring his laptop, let you review that discovery, let you read the written discovery, and then have you report back to me as to whether or not you want to accept the state's offer, or if the state wants to accept any counteroffer that you want to make.
Yes, sir.
So what I'm going to do is Mr. Gimbel, if I reset this for just 3 weeks, would that you believe that'd give you enough time to bring the discovery to Mr. Wilburn so that he can view it for himself and he can read through it so he can make a decision?
That should be, Your Honor.
All right, we're going to set Mr. Wilburn then for a hearing, a docket call hearing on January 28th. And we'll set that at 1:30. That's the contested evidentiary docket day, but we'll set that at 1:30. So, Mr. Gimbel, on that day, you'll most likely need to appear via Zoom, and we'll have Mr. Wilburn zoomed in from the jail.
Okay, Your Honor.
All right, and so Mr. Wilburn, if between now and the 28th, you still want to request new court-appointed counsel, I'm going to ask that you have that put in writing and signed and submitted to the court before January 28th.
Yes, sir.
All right?
Yes, sir.
All right.
Thank
You're
you.
free to go. Who is this, Mr. Gimbel?
This is Kenneth Davis.
CR 24/7, State versus Kenneth James Davis, set for docket call. Go ahead.
We have received all the discovery and the material and have reviewed that with Mr. Davis. And we have received a plea offer in the matter, and he has rejected that offer.
And what is the offer?
The offer was 12 months state jail.
And does Mr. Davis understand that rejection of the state's offer today means that the court may not entertain a plea bargain in the future?
I have informed him of that, Your Honor.
And how long has Mr. Davis been incarcerated?
It should be 115 plus this month. Plus this month.
At least 4 months, Your Honor.
All right, the court will set Mr. Davis for jury selection beginning March 1st. Mr. Davis, if you make bond or bail in this case before March 1st and you're released, then I want you to stay in contact with Mr. Gimbel and he'll tell you how to appear before the court on March 1st. You understand?
Yes, sir.
All right. Mr. Gimbel's going to give you a notice of appearance here with that date. Once you see the yellow copy, you can step away.
And Your Honor, that is all I have this afternoon. May I be excused?
Yes, sir. Thank you, Mr. Gimbel.
I didn't know you were testing class. I mean,
Mr. Adams, is this Mr. Russell Goss?
yes, sir, it is.
All right, CR 2212, we're set for status. I think we were previously set for a plea back in November. Mr. Goss failed to appear.
That's right. I think it was November 3rd, Your Honor.
What's the announcement today?
Well, I would like a little bit more time with Mr. Goss, a week or so. The reason being, I wasn't aware that he was in custody until yesterday when I got notice that he was being added to today's docket. We still have a plea offer from the state. I thought we were going to accept the plea offer and have a sentencing hearing back in November. If I could just have a week or so to I can confirm that with Mr. Goss here today, but we don't need, we don't have, I don't think we have the paperwork completed. And of course it's going to take at least a day for the DA's office to put those documents together, get them to me and for me to go through them with Mr. Goss. I don't think it can be done here this afternoon.
Is the state revising its offer or extending the same offer that existed before?
Your Honor, the state would leave that offer open for Mr. Goss. Off the top of my head, I don't remember what the offer was. Ms. Abney, however, did not have this on her list. I did not put this on her list for paperwork today. So Mr. Adams is correct that we are not prepared to proceed today.
And just for the record, the offer was for 9 months, state jail facility, and a $2,000 fine.
Okay, thank you, Mr. Adams.
Mr. Goss has just indicated to me that he does want to accept the state's plea offer, so we can set it for a plea hearing.
Give me just one moment. All right, Mr. Goss, I'm going to set you for a plea. I'm going to do it sooner than later. I'm going to set it for next Tuesday, the 12th at 1:30. Mr. Adams, are you available on that date?
Yes, sir. That's the Tuesday, the 12th.
Tuesday, the 12th at 1:30.
Your Honor, we've got Mr. Hyde is stepping out to get his client to bring him in while I do a transfer or a switch of inmates.
Okay.
Judge, while we are holding in the court, would you mind if we went back on the record on Mr. Doan's 2 cases?
Yes, ma'am. Mr. Adams. Go ahead, Ms. Heisman.
Judge, Mr. Adams and I have been emailing back and forth. Both of us have checked the TDC website, and it appears Mr. Doan is currently serving time for the charge, which is the basis of our revocation. Given his time in the Texas Department of Criminal Justice, the state at this time is going to submit to the court the email and, of course, copy Mr. Adams on that, just a motion to withdraw the MTR and let his community supervision expire. And the state is not going to proceed with prosecution of that MTR at this time based on his time served in TDCJ.
Okay, so you're going to e-file a motion to withdraw?
Yes. And then we will also submit the motion withdraw should also withdraw that MTR warrant, but if we need to submit a separate motion to withdraw the warrant, we would be happy to do that as well.
Okay.
And I'm fairly confident that there won't be an objection to the motions.
Okay. And so I guess, do you have an ability to contact Mr. Doan, Mr. Adams?
I've got the, I think I have some contact information for a relative in his file, and I'll see about, there's always the U.S. Postal Service. I have his address.
Okay. Well, and if he gets out, if the motion to withdraw and the motion to adjudicate warrant gets withdrawn and there's no hold and that gets communicated to TDC, then they're gonna parole him out and he should do what you asked him to do. If not, I guess he'll show up here on the 9th.
Right. Okay. All right. Thank you.
You're welcome. Mr. Hyde, are you ready?
We're ready, Your Honor.
And you got Mr. Martinez?
Yes, Your Honor.
All right, this is CR 19-181, CR 2054, State versus Cruz Martinez. Are we entering the plea today?
Yes, Your Honor.
All right, and who's going to be conducting the plea for the state?
I think lip reading Hillary said she was. She's on mute.
Yes, Your Honor. Sometimes the unmute works and sometimes it doesn't.
Dan, can you tell me the terms, Ms. Heisel?
Pull up the plea, Your Honor.
Your Honor, it's 20 years TDC to run concurrent on both cases.
As charged, what's the level of charge in CR 2054?
First degree felony, Your Honor.
And what's the credit time for Mr. Martinez?
Over 150 days.
Is that the same on both?
Yes.
And the court costs?
$290.
Is there a fine?
No fines.
Are there reimbursement fees?
Yes, Your Honor. And the cause number ending in 81, it's $60. And the cause number ending in 54, it's $35.
What's the level of degree on the 81 offense, the unlawful possession of firearm by felon? Is that a third, or it's obviously enhanced?
It's a third degree, Your Honor.
But it is
enhanced. It's been enhanced with one paragraph to make it a 2 to 20.
And on the plea paperwork, is there a plea of true indicated on the paperwork to the enhancement paragraph?
Yes, Your Honor.
So it's third degree enhanced to a second?
Correct.
Okay. And the other one is just a straight first degree?
That's correct.
All right. All right, Mr. Martinez, if you will, please, sir, raise your right hand. I'm going to place you under oath. Mr. Martinez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, make sure you speak up loudly and clearly. Step up as close as you can. You can, you can put your hand down. My court reporter is here with me in the courtroom, and it's going to be difficult to hear through a mask, number one, but you're going to have to really talk up, okay?
Yes, sir.
All right, thank you. That's better. All right, Mr. Martinez, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed of any kind of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Heath Hyde. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Do you have any questions about any of the paperwork that you've reviewed and signed today?
No, sir.
Where your signature is in the paperwork, would you swear that that is your true and correct signature?
Yes, sir.
And you only put your signature in there once you knew what you were signing. Is that correct?
Yes, sir.
Now, you've heard Mr. Hyde read to the court what the plea agreement was between you and the state. Is that your understanding of the plea agreement in each case?
Yes, sir.
And Mr. Hyde, do you believe Mr. Martinez to be competent today?
Yes, Your Honor.
And you explained to him his legal and constitutional rights?
Yes, Your Honor.
All right, Mr. Martinez, in cause number CR 19-181, you are charged with the felony offense of unlawful possession of firearm by felon. That is a third degree felony offense. The state has included in the indictment an enhancement paragraph, which would, if true, raises the range of punishment to that of a second degree felony, which carries a range of punishment of not less than 2 years or more than 20 years confinement in TDCJ and a fine not to exceed $10,000. Do you understand the range of punishment in that case?
Yes, sir.
In cause number CR 25-4, you're charged with the First degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 200 grams, but less than 400 grams. That offense carries a range of punishment of confinement in the Texas Department of Criminal Justice Institutional Division for a period not less than 5 years or more than 99 years or life, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
At this time, Mr. Martinez, how do you plead to each charge?
Guilty.
And Mr. Martinez, are you pleading guilty to each charge because, in fact, you are guilty of committing each charge?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to either one of these charges?
No, sir.
Court will accept Mr. Martinez's plea of guilt in each case. Mr. Hyde, is there any objection to States 1, the stipulation of evidence?
No, Your Honor.
Court admits States Exhibit 1 and takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Ms. Heisel, if you'll give me a brief summary of the facts, please.
Yes, Your Honor. Mr. Martinez was driving a vehicle on I-20 that was pulled over for left lane not passing. Mr. Martinez was notified that he was going to be receiving a warning for that. However, both him and his female passenger were acting extremely nervous in the vehicle. So the officers began to question them. Their stories didn't add up. Officers, based on the behavior of both people and the stories given, asked for consent to search the vehicle. The defendant denied the search, but it was Sergeant Bridger with the sheriff's office who had the K-9, so he ran the K-9. Rico did alert on the vehicle, so they conducted a probable cause search, and I'll get you the exact amount, Judge. The labs came back 362.5 grams of methamphetamine was found in the trunk, as well as a firearm, and Mr. Martinez is a convicted felon.
Thank you, Ms. Heisel. Mr. Hyde, any objection to that summation?
No, Your Honor.
All right, based on the evidence, the court will find that there is sufficient evidence to convict Mr. Martinez of each one of these offenses. The court hereby follows the plea agreement in each case. In cause number CR 19181, the firearm charge, the court hereby convicts Mr. Cruz Martinez of the unlawful possession of firearm by felon. Let me ask you also, Mr. Martinez, as to the enhancement paragraph in CR 19181, is that enhancement paragraph true or not true?
True.
And Mr. Martinez, are you pleading true to that enhancement paragraph because that paragraph is true and for no other reason?
Yes, sir.
All right. Court's going to find the enhancement paragraph to be true. Court hereby assesses your punishment in this cause at 20 years confinement in the Texas Department of Criminal Justice Institutional Division. The court does not assess a fine, does order court costs in the amount of $290, orders Mr. Martinez to pay reimbursement fees of $60, and the court awards 150 days credit towards the sentence in that cause. In CR 254, which you are charged with manufacture and delivery of a controlled substance in penalty group 1, the court hereby assesses your punishment at 20 years confinement in the Texas Department of Criminal Justice, orders you to pay court costs of $290, a reimbursement fee of $35, and also awards you 150 days credit for the time that you have spent in jail on this cause. Mr. Martinez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step to your left to be fingerprinted, and then you'll be taken into custody at this time. Anything further, Mr. Hyde?
No, Your Honor, that's it. Might be excused.
Yes, sir. Thank you. Good to see you.
Thank you, you too. Here.
Mr. Adams, are you back for another dismissal?
I'm back.
Who's going to be your next client, Mr. Adams?
It's going to be Rochelle Kofer, Your Honor.
All right, this is cause numbers CR 20285 and 320, State versus Rochelle Kofer. We're set for pretrial today, Mr. Adams.
That's correct, Your Honor. I have what I believe is all of the printed materials so far as discovery is concerned. I filed an omnibus motion for discovery, but really the point of the motion for discovery, practically speaking, is for any video that may exist, whether officer body cam or officer patrol unit dash cam or in-unit car video. I don't have any to my knowledge. If it is on the discovery portal, then I have overlooked it and I apologize. But in any event, I'm lacking that. If it is available, then I haven't had time to review it yet. One more item, Your Honor. I am anticipating, or I'm not anticipating, I intend to file a motion requesting a competency evaluation for Ms. Kofer. She's indicated to me not insignificant history of mental health issues and treatment for those issues. In our conversations, I tend to think that she understands what we've talked about, but to err on the side of caution, I feel it's incumbent upon me to ask for that competency evaluation.
So you're going to file that in a motion form and support it with an affidavit?
That is correct, Your Honor.
Okay. All right, the court will set Ms. Kofer then for an additional pretrial for you to acquire the video. And State, do you have any information on whether or not there's video evidence in this case?
Judge, it does appear that there are 2 videos. I'm not sure why Mr. Adams has not received them. I will look into that and get with Mr. Adams, make sure that they are made available to him post haste.
All right, court will set Ms. Kofer then for pretrial on February 23rd.
Your Honor, I don't have any other issues regarding pretrial for Ms. Kofer's cases today. That's the last item I have on the docket. When we go off the record, may be excused.
Yes, sir.
Okay, thank you.
Judge, if I may very briefly, it does appear that copies were made and picked up by Mr. Adams at the beginning of December. If he has lost them, if he'll get with our office, we can make another copy.
They are probably hiding in a prodigious stack that I have on my office desk. So I'll revise my announcement to say that while I've received the video, I have not yet had sufficient time to review it.
That's fine. If you can't find them, Mr. Adams, just let us know. We'll get you another copy.
Okay, appreciate that.
All right, thank you, Ms. Kofer. We'll see you on February 23rd.
Thank you.
Mr. Sanders.
Mr. Sanders, is this Mr. Carmona?
It is, Judge.
All right, this is CR 243, State versus John Michael Carmona. We're set for plea today. Is that right?
Yes, Your Honor, and today, after talking with the state, I think what we were going to do is a jury waiver and ask to reset it for a plea. Mr. Carmona has undergone quite a few medical treatments dealing with his eyes, I think as a result of diabetes. He had a procedure done yesterday, is scheduled to have another one done tomorrow. And so and I provided the state with documentation, and I think he has a follow-up on the 14th at least, and depending on how everything goes tomorrow. So Judge, because the offer is for some time in jail under 1244A, we were asking if we could reset the plea and sentencing for about 30 days.
Does the state have a position?
Your Honor, we have been provided that medical documentation to confirm he's currently undergoing treatment. We have no objection to him resetting 30 days to take care of that so he can serve his jail time without interruption.
And Judge, we can go ahead and do the jury waiver. We have signed that today.
All right. And is the state joining in on the waiver of jury trial?
Yes, Your Honor.
All right, Mr. Carmona, raise your right hand for me, sir. Mr. Carmona, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Mr. Carmona, have you signed a document entitled Waiver of Jury Trial today?
Yes, sir.
Have you discussed that with your attorney, Mr. Sanders?
Yes, sir.
Do you understand that you have the absolute right to have your case tried before a jury of your peers?
Yes, sir.
You understand that you also have the right to waive that right?
Yes, sir.
You understand that once you waive that right, there's very limited circumstances in which that right could be restored to you.
Right, sir. Yes, sir.
Is this your own intentional and voluntary decision to waive your right to a jury trial?
Yes, sir.
Has anyone threatened you, forced you, or made you feel like you had to waive your right?
No, sir.
All right, the court will approve the waiver of jury trial. We'll find that it's been joined by defense counsel, Mr. Jeff Sanders, and counsel attorney for the state. So the court will set Mr. Carmona for plea on February 9th, and that will be an in-person proceeding in the courtroom at 9 a.m.
And Judge, do you want, because it will be a jail sentence, do you want us to set it for 1:30 or?
Yes, sir, that's better. Yes, sir. Thank you for that. Thank you for catching that, Mr. Sanders.
Well, Judge, I think you caught it the last time, so.
Are we even?
We're even now.
Okay, good. All right, Mr. Carmona, you're free to go. We'll see you back on February 9th at 1:30 at the Vanson County Jail.
Thank you, sir.
Thank you.
Sanders, you need me out here or?
Yeah, keep on waiting.
You want me to wait till you get out?
All right, Mr. Sanders, is this Mr. Key?
Yes, Your Honor, it is.
All right, CR 25-3, State versus Joshua Daniel Key, set for pretrial.
Yes, Your Honor. And Judge, we don't have any contested pretrial issues. We just ask that it be set for a docket call.
Do you have an offer in this case yet?
Judge, I don't believe we do yet. I'll be getting with the state about that, though.
All right, the court will set Mr. Key for docket call on February 9th. And I would ask that the state make an offer well in advance of that time if it's going to. So
Of course.
So that
And,
Mr.
Judge, and they may have, Your Honor. I just may not have checked on the website to see. So it certainly might even be there. I just haven't checked. But
Okay.
Judge, one other matter I wanted to bring up. We'd had the bond reduction hearing back in December where his mom testified. And I think now my understanding is that he's had contact with, okay, that as far as the possibility of him getting a PR bond with an ankle or GPS monitor, if he does bond out, one of the conditions I believe is not to have any contact with his parents because they're the alleged victims in the case. And I was going to see if he does end up bonding out, and is placed on the GPS monitor, if that's something that we could have amended to where he would be allowed contact with his parents. I think from his mom's testimony at the hearing back in December, I don't think that was going to be any issue.
I would like to see a motion to modify the pretrial release conditions and give the state an opportunity to prepare for that and have a hearing.
Okay.
And may need and I'd probably, it's not probably, I'd want to hear more testimony from the alleged victims in that case on the record.
Okay. All right.
So, Mr. Key, we'll see you back on February 9th.
Great, thanks, sir. Thank you, Your Honor.
You're welcome.
Okay. Well,
All right, court call CR 2150, State versus Judson Taylor Brown, set for docket call. Go ahead, Mr. Sanders.
Your Honor, we don't have a plea agreement in this case, and we would ask that it be set for a jury trial. I believe the state's offer was 12 years, and Mr. Brown is rejecting that offer, 12 years TDC.
And does Mr. Brown understand that the court may not entertain a plea agreement between him and the state, even if it's to something much less than 12 years?
Yes, Your Honor, we understand that.
All right, the court will set Mr. Brown for jury selection beginning on March 1st. Mr. Sanders, as you're aware of the court's policy, you're not required to appear on that date unless you receive notice from the court that Mr. Brown's in the top 10.
Okay, all right, thank you, Judge.
If Mr. Brown remains in custody, then paperwork will be sent to him. Mr. Brown, if you make bail, you'll need to contact your attorney so he can give you information on how to report to the court. All right?
well, I'm not in the top 10. I didn't reset it. Right. Yeah. Okay.
Anything further?
No, Your Honor, that's all.
All right.
And Judge, the other person I had, Cody Eden, we had him down for a writ for a bond reduction. His case was indicted, I believe, maybe December 18th. I think it was still maybe the 91st, 92nd day after he was arrested. But after talking to Mr. Eden earlier today, he doesn't want to go forward at this time. We have an arraignment date for January 28th. And so we would just withdraw the motion for the bond reduction. We don't have a need for the hearing.
Okay, and Mr. Sanders, can you e-file an order with that so that we can close down that civil case in the clerk's office?
Okay. Just a separate order saying that we would just withdraw that. Okay. All right.
Yeah, once the writ's filed, it opens up a civil case and it remains there on my docket until I have to set it for a DWOP in a year or something. So if you could non-suit it or just withdraw it with an order, then I'll sign that. It'll clean up the docket.
Okay. All right. That sounds good then, Judge. Thanks.
Thank you, sir. Is that all you have, Mr. Sanders?
Yes, it is. May I be excused?
Yes, sir. Thank you. Good to see you.
See you too.
Your Honor, we'll be bringing Mr. Wood's clients up next.
Okay, thanks. While we're waiting on Mr. Woods, I'm gonna see if I can find Miss Burns. Is Miss Hughes there? And did she provide the urine sample?
No, sir, she is not. When I drove up, I saw her leave in her vehicle and she has not returned.
So she was not there. What time did you arrive?
I was here about 1:20.
And you saw her leaving at 1:20?
Yes.
Okay, so I've already signed that order, so.
I've given it to Aaron to take.
All right, thank you. All right, let's go back on the record for Miss Jeannie Hughes, CR 2216. Miss Hughes was in court this morning. The court set her for a docket call on January 28th. The court also instructed Miss Hughes to appear at the Van Zandt County Justice Center and provide a urine specimen for drug testing. Miss Hughes, based on the statement of Miss Burns, is not at the Van Zandt County Justice Center. The court hereby finds her bail, her or bail to be, or bond rather, to be insufficient, and has set new bail in the amount of $50,000, I believe. No, I believe it's $25,000. Right, who do we have up first, bailiff?
Brett Turnage.
This is Brett Turnage, Your Honor.
How are you, Mr. Turnage?
I'm good. How you doing?
Doing fine, sir. Can you see your attorney, Mr. Wood, on the screen?
Yes.
Okay, this is cause numbers CR 20, 198 and 199, State versus Brett Lawrence Turnage. We're set for pretrial today. Go ahead, Mr. Wood.
Judge, Mr. Turnage has been evaluated by Mr. Proctor, and I believe these two cause numbers, I believe, were in that order as well, but I'm not entirely sure of that. Regardless of that fact, Mr. Proctor has deemed Mr. Turnage to be, at that point, incompetent. And so it's my understanding Mr. Turnage is right now waiting for a bed to open up at Russ so that he can get some appropriate medication that hopefully we can get him back on the right track and we can kind of start to move this thing forward.
Is this the case where Mr. Turnage was evaluated by Dr. Proctor in another court or another jurisdiction?
He was evaluated by Mr. Proctor in another court, Judge. I'm sorry, well, I guess jurisdiction and court, if you want to put it that way, but I think it was a case in Judge Winter's court, I believe.
Okay. And so we don't have any updates on bed availability? Do either one of y'all have updates on bed availability and when Mr. Turnage may likely go into the state hospital?
The state does not. I could inquire upon that, but at this time, I don't have that information.
Okay. All right. Well, I want to set Mr. Turnage then for another day just so that he doesn't sit there without some kind of attention. I'm going to set a status for Mr. Wood. What have I set you for previously today? I see January 28th. That's too soon.
I think you set before March date as well, Judge.
All right. So we're going to set that same March date, March 9th, for competency status. So what that means, Mr. Turnage, is I'm going to keep seeing you until I know that you have been sent to the hospital so you can receive your treatment, okay? You understand?
I do.
Okay. All right. We'll see you on March 9th. Well, hopefully I don't see you on March 9th. Hopefully I get reports that you've received a bed and that you go and get your treatment.
Okay.
All right. Steps. And Mr. Burton? Your Honor, this is Jay Bruner.
Thank you. CR 24-1, set for docket call. Mr. Wood, go ahead.
Judge, Mr. Bruner, I believe he was just arrested, if I'm not mistaken, several days ago. I've not had an opportunity to speak with him much, except for the fact that we have gone over the discovery in his case, and we had actually had started to proceed forward on the matter with me and Mr. Cox at that point, and my hope is that we can get this resolved relatively quickly. I will inform the court that there are some other issues that I need to take up with Mr. Cox and Mr. Bruner and evaluate him a little bit more after I see him. But I'll inform the court on that matter when that time comes. But we don't have any pretrial necessarily at this point, yes.
And Mr. Wood, are you aware that Mr. Cox no longer works in Van Zandt County?
Well, I wasn't until just now, but appreciate that. So we'll be dealing with Mr. Woodwike or Miss Heisel then, I suppose. I hope he didn't get canned, but that's fair enough.
No, he didn't get canned, but if you're waiting on a call back from him, you may be waiting quite a while. And Mr. Bruner's case, this is not this is an original case. It's not a motion to revoke, correct?
That is correct, Your Honor. This is an original case. We've gotten the discovery, and like I said, I've had an opportunity to go over that with Mr. Bruner, but haven't seen him lately.
I'm looking over the docketing, and I see that the reason. Okay, we've had. This is the second docket call, but it appears that Mr. Bruner went MIA back in August of last year. Appears he didn't show up to court, so not good. Okay,
That's correct.
I'm going to set Mr. Bruner then for an additional docket call. I don't want to set him all the way out in March. How much time do you think you need, Mr. Wood? Would you think 3 weeks is too quick?
Yeah. I mean, I think if you want to set him on that January 28th docket, Judge, I mean, it's just going to kind of depend on how I'm able to get back home and then go see him and talk to him. And then, like I said, there might be some other issues that come up. I anticipate that they actually will come up, mental related issues. And so once I see him, I'll do the appropriate things I need to do there. But the 28th, I think, would be a good starting point for us.
All right, court will set Mr. Bruner for an additional docket call on January 28th. All right, Mr. Wood, do you have anyone else? Looking through my docket, I don't see anyone else, but you don't.
Judge, I think that's it. Moment.
Okay, I don't see anyone else. Thanks for zooming with us. We know
I
that
love the Zoom, Judge.
we know that you have the ability to Zoom with a lot of people, but we really appreciate you choosing us to Zoom with today.
I'll always choose my friends over there. So look forward to the next Zoom. Look forward to seeing you in person, to be honest with you.
Yeah,
Believe me.
Well, I hope that little girl's doing fine, and hope she's in and out and back home.
Yeah, me too. Me too, Judge. I appreciate it. Thank you, guys.
You have a good day.
All right.
Judge Martin,
Yes, ma'am.
what attorneys do you have in the waiting room that are ready?
In the waiting room, I have Carlo D'Angelo.
Okay.
I have Ann Thompson. She was just here for Miss Hughes. She's not going to be. And then I've got one that's called Galaxy S9 and one that's called iPhone. One of those is going to be Miss Beasley, I think. She usually doesn't. She usually puts her name in, but I don't know which one's which. So I don't know if she's in there or not. I think I had a message that said that Deborah Beasley said Carrier is on his son's phone, which shows Justin Carrier. But I don't have a Justin Carrier on my phone or on my Zoom.
Okay. Well, as far as inmates, since you have Mr. D'Angelo ready, I'll go ahead and bring Mr. Ferguson up next, and then the rest we'll just get as we can, if that's okay with you.
You know what, Mr. Ferguson.
For Mr. D'Angelo?
Miss, hang on just one moment before you bring Mr. Ferguson up.
Okay.
Just one moment. Mr. Woodwike and Ms. Heisel, I'm going to invite you to a breakout room. Oh, author. Just one. Bailiff, I'm ready for Mr. Ferguson. Thank you, Ms. Heisel. I'm going to bring in Ms. Thompson real quick.
All right, Your Honor, Mr. Ferguson is on his way up now.
Okay, thanks. I'm going to talk to Ms. Thompson real quick, and then we'll call Mr. Ferguson.
Yes, sir.
Uh, Ms. Thompson, can you hear me?
Top right, I've got enter full screen, minimize.
Me? Hello, Judge.
Mr. D'Angelo,
Yes.
I think he's attending to something else. We do have your client on the way up, though. He should be here shortly.
Okay. Thank you.
How are you doing? Better. Mr. Ferguson, if you will go and just stand on that podium, sir.
Mr. D'Angelo, can you see and hear me okay?
Judge, can you hear me?
Yes, I can hear you now. All right,
Excellent.
Are you ready to proceed on James Corey Ferguson, CR 17-7?
I am, Judge.
All right. I believe we're set on a motion to revoke today. Go ahead.
Judge, firstly, I'm in the parking lot across the street from the courthouse because I had a little bit of a misunderstanding as to how this docket was going to run today. When I came up to the courtroom, I was advised that this was going to be a jail docket, so that's why I'm logged in from my car. I would be requesting an extension, Judge, for two reasons. One, I met with my client last week via Zoom, and prior to meeting with him, I had requested some discovery on one of the underlying allegations that's the substance of the violation in this case. And subsequent to that meeting, the state has provided me the probable cause and police report for a new substantive arrest, which is the majority of the violations and obviously the most serious violation in this case. I have not had an opportunity, despite my best efforts this week, to try to schedule a follow-up with the jail, to do a Zoom conference with my client to review that police report, as well as discuss the plea offer that came in conjunction with that police report. I've been trying both via email and phone, but just have not been able to coordinate that, Judge.
Okay. How much time would you be requesting?
I'm asking for 2 dates, Judge, if the court will indulge me, because I've also been made aware through my client's family that he's requesting that I file a motion for a bond. This is a no bond warrant at this juncture. So what I would ask, Judge, is if you could set me a hearing for a bond reduction and or status. And if I can get this case resolved by that point, we'll come in and resolve the case, or in the alternative, proceed with a hearing on the bond reduction. And if we need to proceed to a hearing on the final revocation, set a separate hearing a little bit later down the road so that I'd have enough time to get discovery, because this is a victim case and I really need to see the body camera and the video and photographs of the alleged injuries before I can proceed.
State, do you have any position?
Your Honor, I am not opposed to that. I did provide the written discovery on that new offense to Mr. D'Angelo in conjunction with the MTR. We don't have the video burned for him yet, but if he is requesting that, we can certainly get that for him. I'm also interested to know, just because I don't think I have it officially down, whether or not Mr. D'Angelo intends on representing Mr. Ferguson on that new charge as well.
I don't have a problem putting in a letter of representation on that matter.
And in reviewing the state's motion, that's one count of 5 counts. Is that correct?
Correct, Your Honor. I believe that the rest are basically technical violations.
Correct, Judge.
Okay. All right. So about how long are you requesting, Mr. D'Angelo?
Judge, if you could set me perhaps next week for a potential status and or bond reduction hearing, that would give me time to meet with my client via Zoom and review the plea offer and discuss his options, as well as get a motion to set bond on file. And if we can resolve it next week, great. If not, perhaps set me out a final revocation hearing, maybe 2 weeks to follow that, Judge.
I can set you on the revocation hearing, contested hearing, in about 3 weeks.
Okay.
The next week's docket's pretty full with regards to trying to set a time to file a motion to set bond. Any objection to taking up both matters on the 28th?
Whatever fits the court's schedule, Judge. I do have a couple of ALR hearings that are currently set on January 28th. I believe those are in the morning. What time would the court be considering for the 28th for a setting?
We can set at 1:30.
Okay. Would that be an in-person appearance, Judge, since it may be an evidentiary hearing?
It's a good question. That's a real good question. There's so many things that the court has to do to determine in person. It's likely that it would be an in-person. I anticipate you would have testimony and exhibits from the state and from the defense, and it could result in the incarceration of Mr. Ferguson in the Texas Department of Criminal Justice. So I would anticipate that it would be an in-person hearing. I just have to make findings on the record to substantiate that.
Okay, Judge, if I can get this resolved with the state and with my client before that date, I'll let your chambers know. And perhaps we can either move the date up or change the nature of the hearing, but I'll go ahead and calendar 1:30 on January 28th.
Okay, court will set it for a contested hearing on the motion to revoke. And then that date, if for some reason there's an agreement to pass the motion to revoke hearing, then the court would entertain hearing the motion to set bail.
Understood.
Okay. All right, you understand everything, Mr. Ferguson?
Yes, sir.
Okay. All right, we'll see you back on the 28th. About 3 weeks. Is that all you have, Mr. D'Angelo?
That is all I have, Judge. Thank you.
All right. Sorry for any confusion about appearing Zoom, on Zoom, and all those good things.
It's just part of the new world we live in, Judge. I completely understand.
Unfortunately. All right. Thank you, Mr. D'Angelo.
Thank you.
Your Honor, this is William Wilson approaching.
All right, Mr. Wilson. This is cause numbers CR 18 521 522 and 32 and CR 19 327. The court was notified, Mr. Wilson, by Mr. Bill Stevens. He was in court earlier. He appeared via Zoom on another client's case earlier this morning. Over the lunch hour, he contacted my office and indicated that his wife was having to be treated at the doctor for her COVID diagnosis, and it was one of those appointments that they had to ask for, and they worked her in, and she's not doing as well as he had hoped. So he contacted me to let me know that he was not going to be able to appear in court today. So what I'm going to do, Mr. Wilson, is I'm just going to set you out for another couple of weeks and give Mr. Stevens a chance to make an appearance once he tends to his family. Okay? Okay? You understand? Okay. All right. So January 28th at 9 a.m. And if Mr. Stevens contacts me sooner and says that he's available, then we'll move your hearing up sooner if we can.
I just been waiting for him to come down here and talk to me. So he's gonna be here. So I see that he's been having some problems. I'll be praying for him today.
Yes, sir. He did indicate to me that it was his intention to be there today to talk with you about the case, and that his wife called him and she had to go to the doctor, and is not doing as well as he had hoped. So he told me he'd get down there as soon as he could. All right. Thank you, Mr. Wilson.
Your Honor, I'll need just a couple of minutes to get the others.
Okay, thank you. I'm going to try to bring in Miss Beasley if I can find her. Miss Beasley, can you see and hear me?
Yes, sir.
Okay, I didn't know you were logged in because it just said iPhone, so I didn't know. I would have pulled you in sooner, but I had a bunch of people in the waiting room, and if your name's not entered on your device, it doesn't tell me who's there. So,
Well, it should be, but I'll check on that, Judge.
yeah, you can see on the screen right there where it says iPhone.
Uh-huh.
Yeah, whenever you log in, before you hit enter, you have to go in there and you have to change your device name. Like that. And that way it shows me when you log into the waiting room, it'll show me that you're there, and I can make sure I get you in. All right,
Okay.
looks like Mr. Carrier is online with us here, and he just connected to audio. Let me ask him to unmute. I'll send him a prompt. Mr. Carrier, can you unmute your device?
Yes, sir. Yes, sir.
Yes, I can hear you. Can you hear me okay?
Yes, sir, I can.
All right. And can you see and hear your attorney, Miss Beasley? She's online with us.
Yes, sir. I can't see her right. I can't see her right now, but I did.
I'm sorry. I can't really understand what you're saying, Mr. Carrier.
I said I did see her, but I don't see her right now.
Okay. All right. Well, you may, if you're on your phone, you may have to move left or right on your screen to be able to see her. But okay, this isn't cause number CR 27-4, State versus Michael David Carrier. It's my understanding that we were set for plea today. Go ahead, Miss Beasley.
That is correct, Your Honor, but my client informed me this morning that he's sick. He's had some serious health issues, was running fever yesterday, and we were asking for a reset in order for him to recover before he has to serve his 10 days in jail.
Mr. Carrier, have you tested positive for COVID or have you undertaken a test?
I haven't been tested, sir. I just started feeling sick, and I've been going back and forth to the store, but I just don't feel very well. I don't feel very well at all right now. I've been running fever off and on, diarrhea, food don't taste right, and just got a lot of physical things going on with me.
All right, State, do you have a position?
Your Honor, we reset Mr. Carrier's plea last month for him to care for a family member before he went into jail. And given his symptoms, I'm not sure that the jail would accept him right now anyway. So we are going to be agreeing to let him reset one more time. However, this will be the last time we would agree to a reset.
Ms. Beasley, are you available on January 28th?
Let me check, Judge.
That's 3 weeks from today.
Yes, sir.
Okay.
I am.
Thank you. So, Mr. Carrier, I'm going to set you for your plea before the court on January 28th. And I believe I heard that the plea agreement was 10 days in jail. Is that correct?
Yes, sir.
That is correct, Judge.
All right. So I'm going to set you on January 28th at 1:30, and I'm going to ask you to report to the Van Zandt County Jail at 1:30.
I wish I could have done it today. I just don't get nobody sick, sir.
I understand. I appreciate that. So we'll see you in a couple weeks. Hopefully you feel better, and we'll work on your case then.
Thank you very much.
Thank you, Ms. Beasley. All right.
May I be excused?
Yes, ma'am.
Thank you.
You're welcome.
Yes, ma'am.
And what is your name? What is the name?
Josh Martin.
Mr. Martin?
Yes,
Okay,
ma'am.
thanks.
All right, this is cause number CR 19180, State versus Joshua Mac Martin. We're set for a motion to revoke today. Mr. Martin, do you intend on hiring an attorney to represent you in this matter?
Yes, sir, I do.
And about how long will you need to hire that attorney?
Probably next week or two.
Next
Week or so.
Okay. If I give you 3 weeks, do you think that would be enough time?
Yes, sir.
Okay. What I'm going to do is reset your motion to revoke hearing until January 28th and put you down for status of retaining an attorney. So we're going to give you, the bailiff's going to have you sign this notice of appearance, and it'll have that next date on there.
Yes,
So
sir.
when you speak with the attorney, let them know that you're set for January 28th at 9 a.m.
Thank you, sir.
You're welcome, sir.
Oh, no. Just have a seat. Jackson?
All right, this is CR 19-19, State versus Justin Mark Jackson. We're set for hearing on the motion to revoke. Mr. Jackson, are you going to hire an attorney to represent you on this matter?
No, sir.
Are you going to request a court-appointed counsel?
Yes, sir.
And have you filled out the application and requested that to be processed at the courthouse?
Yes, sir.
When did you do that?
Yes, last night.
Last night, okay. And my indigent defense coordinator is currently having to work remotely, so we haven't had an opportunity to have that sent to us. So what I'm going to do is I'm going to have my coordinator find that, and we'll review it. We'll have to reset your case today. And give me just one moment here. Let me see when next time I can get you in. All right, Mr. Jackson, I'm going to set your case again for it's going to be about 2 weeks. It's going to be January 26th. What I'm going to do in the meantime is find that paperwork, and if you qualify for a court-appointed attorney, then one will be appointed to you without a hearing, and that attorney will be in contact with you. If I find that you do not meet the qualifications for a court-appointed attorney, we'll let you know that fact so that you can start calling friends or family or whatever you need to hire an attorney, okay?
Okay, yes, sir.
All right, so if you do qualify, we'll have one there hopefully within the next week or so to start talking to you about your options.
Yes, sir.
Your copy, sir. Just have a seat. Welcome back, sir. Judge is going to visit with you, but I'm going to let you do this paperwork while you guys. Got your warrant.
Before we proceed with our extradition, Ms. Thompson, are you there? not there. Do we have anyone else on the docket this afternoon that you're aware of, State?
Not that I'm aware of.
No,
Judge.
Your Honor.
Okay. All right, I think that will conclude our jail docket. I appreciate you guys helping me today. I'm going to now do an extradition with Mr. Williams here. And then if Ms. Thompson comes back on, I'll let her know the status of her client who did not provide the
Okay.
changes. Okay.
Thank you, Your Honor.
Thank you, Judge.
Good to see you. Appreciate it. All right. Are you Frederick Williams?
Yes, sir.
Mr. Williams, will you raise your right hand for me? I'm going to place you under oath. Mr. Williams, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. All right, Mr. Williams, you are currently being held in the Van Zandt County Justice Center on a fugitive from justice warrant. It appears to me that after reviewing your records that you are wanted in the state of Mississippi, specifically Hinds County, Mississippi, on the felony charge of a stolen weapon or possession of a stolen weapon, a felony offense. And at this time, the state of Mississippi is requesting that you be returned to their jurisdiction. Since you are in Texas, there are certain rights that you need to be aware of. You do, and you have the paperwork before you, correct? And you've taken a chance to read that? Have you had the opportunity to read your paperwork yet?
I'm sorry. He's talking about all of this.
Have you read through that paperwork yet, Mr. Williams?
Yes, sir. Stand up.
He's just had a couple of moments up here at the podium, Your Honor.
Okay. Well, I'll tell you what. Let me speak with Ms. Thompson while Mr. Williams takes a moment to read. I don't want him to be rushed, okay? Go ahead and read that, and I'll be right back with you, Mr. Williams.
Thank you, Your Honor.
And I'm going to go ahead and mute you at this time, bailiff. I got you. All right, Ms. Thompson.
Yes, Your Honor.
I wanted to let you know that Ms. Hughes was at the Van Zandt County Justice Center, according to Ms. Burns. Ms. Burns indicated to me earlier that Ms. Hughes was at the Van Zandt County Justice Center when she arrived, which was about 1:20 p.m. And upon Ms. Burns arriving, she saw Ms. Hughes leaving the Van Zandt County Justice Center. And at no time during today's docket did she enter the Justice Center or make contact with anyone to our knowledge. So the court, is going to find that she has failed to provide the urinalysis sample as requested, and is going to find her to be in violation of her pretrial conditions, and has found her bond to be insufficient, and will issue a warrant and new bail in the amount of $25,000.
Yes, Your Honor.
That,
May I be excused, Your Honor?
Yes, ma'am, you may. Thank you. Thank you for logging back in.
Yes, sir.
All right, have a good day. All right, has Mr. Williams had enough time to read over the paperwork?
Your Honor, he has. He might have some questions or need some clarification on the waiver of formal extradition, but other than that, he has read it all.
Okay, good. Yeah, we're about to go over that. All right, Mr. Williams, I'm just going to repeat for clarity's sake. You are currently being held in the Van Zandt County Justice Center on a fugitive from justice warrant. The state of Mississippi, Hinds County, has issued a warrant for your arrest for the felony charge of possession of a stolen weapon, a felony offense, and they are requesting that you be returned to their jurisdiction in the state of Mississippi. Due to the fact that you are in Texas, you do have certain rights. I'm going to go over those with you at this time. You do have the right to request the issuance and service of a governor's warrant of extradition. What that means, Mr. Williams, is that you can request that the state of Mississippi formally request that you be brought back to their jurisdiction. The way that would work is the governor's office in Mississippi would have to contact the governor's office in the state of Texas. The two governor's offices would have to confirm that you are the correct individual and that the charge is what they say it is, and that it is legally sufficient for you to be returned from our state to their state. That's a formal process that takes some time for them to do. You also have the right to waive that extradition and voluntarily go back to the state of Mississippi. If you choose to voluntarily waive your right to extradition, then the Van Zandt County Justice Center would forward information back to the state of Mississippi, and the state of Mississippi would then be given so many days to come and pick you up. You would not stay more than 30 days in our jail without the state of Mississippi picking you up. If they did not come back to pick you up within 30 days, I would conduct a hearing and most likely release you on bail. You also have the right to obtain a writ of habeas corpus to test the validity of your arrest, and you would also have the right to the appointment of counsel to do that. So at this time, you really have two main options on the table. First option is, do you want to be formally extradited back to the state of Mississippi, or do you wish to waive your right to extradition? Do you have any questions?
Yeah, question.
Okay.
Like if I agree to the extradition, how many days do I have?
If you agree to the extradition, usually they're going to pick you up within 10 days, most likely. Could be sooner than that. That's the quickest way back to Mississippi, is to waive extradition. So I couldn't guarantee you how long it would take them to get here, but it's usually, I think, within 7 to 10 days. Could be sooner.
I'll go with that one.
You want to waive your right to extradition? Do you understand your other rights as I have explained them to you?
But whichever one be the fastest I agree with.
Okay, but do you understand the other rights that I've explained to you? Do you understand that you do have the right to say no, that you don't want to go back to Mississippi, and you can make the state of Mississippi formally request that you be returned through the state of Texas and the governor's office? Do you understand that?
Yes, sir.
Okay. All right, then I'm going to approve your waiver of extradition, and you have there in front of you a document called Waiver of Formal Extradition. If you will sign that document will then be sent to the state of Mississippi, and they will legally be entitled to pick you up upon arrival. All right, Mr. Williams, do you have any other questions?
Sir, when the day just starting today, or it started since I did all my bonds and stuff up to this way?
Does what start?
The time frame.
No, the time frame starts as soon as we conclude this hearing and the paperwork is sent to Mississippi. So it wouldn't start until we have this hearing. I understand that you've been in custody since December 15th. Is that right?
Yes, sir.
Yeah, I believe that the sheriff's office, the former administration, no one contacted us to tell us that you were over there. Otherwise, we would have had this hearing much sooner. So your time frame is going to start today. Now, you went into custody on December 15th. If you're not out of custody by January 15th, then I will come and we'll have another hearing and we'll talk about what your options are then, okay? And we're going to relay that fact to Mississippi that you've been here for what, 15, about 20 days so far. Okay. Any other questions?
No, sir.
Okay. All right. So once you sign that, then the bailiff will send that to the proper people and they'll send that to Mississippi and they'll begin the process of picking you up.
Yes, sir.
All right. Thank you, Mr. Williams.
All right.
Thank you, bailiff.
Is there anything else I can help you with, Your Honor?
No, just so long as when you turn that paperwork in to the appropriate department over there, that it's maybe if we can expedite that processing since Mr. Williams has been held since December 15th without the court knowing.
I'll make sure they're aware.
Thank you, bailiff. I appreciate all your help today.
Thank you, sir. We'll see you in just a bit with the other paperwork.
Yes, ma'am.